Hello friends, this is Advocate Sarita Kumari. I am going to discuss about reasonable opportunity, the importance of reasonable opportunity and hearing in the context of penalties under Section 270A of the IT Act. The issuance of a notice under Section 274 read with Section 270A of the Act by the assessing officer marks a significant procedural step in the levy of penalties. Section 274 of the Act outlines the procedure for the imposition of penalties and mandates that no order imposing penalty shall be made unless the assessee has been heard or given a reasonable opportunity of being heard. This provision underscores the fundamental principle of natural justice, which is pivotal to the fair and just administration of tax laws. Reasonable opportunity of hearing. The essence of a reasonable opportunity of hearing lies in ensuring that the assessee is informed of the grounds on which penalties are being considered and is provided with a fair chance to present their case. This procedural safeguard ensures that the AO's decisions are not arbitrary but are based on a thorough consideration of the facts and merits presented by the assessee. Role of Section 274. Section 274 of the Act is designed to uphold the principle of natural justice by ensuring that the assessee's right to be heard is respected. It stipulates that before levying any penalty, the AO must provide the assessee with a reasonable opportunity to explain their position. This opportunity is not merely a procedural formality but a substantive right that ensures transparency and fairness in the penalty proceedings. Section 270A of the Act pertains to the imposition of penalty for underreporting and misreporting of income. It is crucial to note that the imposition of penalty under this section is contingent upon the facts and merits of each case. The AO is required to consider the explanation and evidence provided by the assessee before arriving at a decision. Therefore, the opportunity of hearing plays a critical role in determining whether a penalty should be imposed. The principle of natural justice. The principle of natural justice is a cornerstone of the legal system and is integral to the fair administration of tax laws. It ensures that decisions are made impartially and are based on a fair evaluation of the facts. In the context, penalties under Section 270A adhering to this principle means that the AO must provide the assessee with a genuine opportunity to be heard and present their case. Non-mandatory nature of penalties. Given the requirement to provide a reasonable opportunity of hearing, it becomes evident that the imposition of penalties under Section 270A is not mandatory. The AO must exercise their discretion based on the facts and merits of each case. If the assessee presents a credible explanation and substantiates their claims with evidence, the AO may decide not to impose a penalty. This discretionary power ensures that penalties are not imposed arbitrarily and that each case is evaluated on its own merits. In conclusion, the issuance of notice under Section 274 read with Section 270A of the Act and the provision of a reasonable opportunity of hearing are critical to upholding the principles of natural justice. This procedural safeguard ensures that the assessee's rights are protected and the penalties are imposed only after a fair and true evaluation of the facts. The non-mandatory nature of penalties under Section 270A underscores the importance of the AO's discretion and the need to consider each case on its merits. This approach promotes transparency, fairness, and integrity in the administration of tax law. Because the opportunity of hearing is not a mere formality, but it is to adhere to the principle of natural justice. Therefore, in our considered view, the penalty under Section 270A of the Act is not mandatory and it is based on the facts and merits placed before the AO.